Turn to People versus Durst. Mr. Durst is here with Mr. Chasnoff and Mr. DeGuerin. We have Mr. Milius and Bailey in the council table and Mr. Anderson. Also, Mr. Bevel, our witness, has resumed the witness stand. I'll remind you, you are under oath. Mr. DeGuerin, you may continue cross-examining the witness.
Yes, Your Honor, we decided not to do the demonstration, and I have no further questions.
Ah, very good. Then, Mr. Milius.
Thank you. Can we put up, I'm sorry.
Oh, the exhibit number? 259.
259, please. Oh, switched it. No, that's all. Give us 1 second and but it's not, it's up over there. There we go. I want to ask you about the relative positions described for Morris Black in the animation, as well as where you place the head based on the physical evidence, and the void pattern. I want to focus on the void pattern. Why is it important to the defense that the head be towards the left as opposed to the right? What happens when you move Morris's head towards the right in this video?
As the head moves toward the right, towards the yellow lines, it also requires the gun and body position of Mr. Durst to travel farther that direction, which is going around the corner of the doorway.
And if he moves further away, so just to clarify, if you move the head, Morris's head, his body comes with it, he moves closer into the kitchen, that Mr. Durst then comes with him around that corner, what would happen to the physical evidence if you have a shooting in that scenario?
The stains, and may I stand and point?
Absolutely.
The stains that are in this area with the head moving over, the gun and arm has to move. This would likely have been blocked. And we certainly would no longer have what is shown as blood on the inside door, because it would be passed farther to the right.
So essentially there'd be a void pattern?
In this area right here where we have stains, it should be blocked, yes.
Okay. Mr. DeGuerin asked you about an oval pattern. When you look at the evidence and you try and determine where the source was, where the head was, do you look at only the pattern?
Well, the oval pattern, as we stated previously from what the position is shown, the oval pattern is absolutely possible. It's the individual stains that will either you can't tell further, or you can support, or it's in disagreement, and stains 2 and 9 are in disagreement with that position.
So when you say that position, you mean the position in the animation?
Yes, sir.
So when you look at the 2 and 9, which are the stains that have the direction of travel, that is indicative of the physical evidence showing that the head cannot be where it is in the animation.
Correct. Those stains should have been angled from left to right and going down.
But they are not.
They are not.
Up and down.
Correct.
And that shows that that the head should have been where the yellow is.
In my opinion, yes, sir.
Now, Mr. DeGuerin asked you, in a laboratory, backsplatter in a perfect world might be a perfect circle, right? Do we live in a perfect world when you look at the physical evidence at a crime scene?
No.
In your experience, do you see backsplatter that is oval shaped?
You can see it in all different manners of abnormal patterns.
I want to talk to you very briefly about the video that Mr. DeGuerin brought up in the email. So basically, you were retained by Mr. Lewin, and he asked you to look at a video, and he sent you a link on Dropbox, right?
Yes, sir.
And were you able to access Dropbox?
I was not.
And so
Pardon me.
you tried to be diligent, helpful, and you went on the internet and you scoured the internet and looked for a video, is that correct?
Yes, sir.
And you found a video where?
It was a program that Dan Rather, so I don't remember the name of it, but
And that video that you found, when it compares to the video that we've given you and that you've seen in court today, how does it compare?
absolutely night and day in quality, and one's longer than the other.
Now, Mr. DeGuerin was asking you questions about the video, obviously. You were on the stand in Galveston in 2003,
Yes,
right?
sir.
Was Mr. DeGuerin was there in court with you, right?
He was.
Well, not with him.
Not with you, not,
Well,
he was
we
in the
were
same,
both present in court.
same courtroom, right?
Yes.
Did he give you a copy of the video there, the perfect copy?
No.
Did he ask you any questions about the animation when he was in court in 2003 with you?
No, sir.
Did he show it to you afterwards?
No, sir.
At any point, has Mr. DeGuerin provided you with this pristine copy of the animation?
No, sir.
Now, in your field, you're asked to provide opinions based on the evidence. If the evidence changes, if you're provided better evidence, different evidence, are you forced to commit to a particular opinion?
No, you have to consider any additional evidence as being added or known when it was previously unknown.
Okay, I want to give you a hypothetical. Morris Black, Bob Durst are in that apartment. Bob Durst pulls out a gun. He's standing across the room, not in the kitchen room, the other room, and he fires out at Morris Black. Morris Black dives out of the way, misses, the gunshot misses, gets embedded into the wall. Morris Black dives behind the kitchen wall there. Bob Durst walks over him, stands above him, shoots him, killing him, cuts up the body, disposes of it in Galveston Bay, and then patches the hole from the gunshot that missed. Is that consistent with the physical evidence?
No evidence.
Overruled.
It's speculation. There's no evidence to support that.
Overruled.
What we were trying to do is refute. If you can't refute under the scientific method, you have to consider that it's still possible. I cannot refute that possibility.
Okay. Now, when you talk about refuting and saying that something is not possible, you've examined the defense animation and compared it to the physical evidence, the testimony of Bob Durst. Can you refute that version? Is that animation that you're looking at, is that consistent with the physical evidence?
It is. It depends on what physical evidence you're talking about. For example, the oval that we talked about previously, 32 by 19.
Let me stop you a second, Mr. Bevel. When you look at the sum total of physical evidence, is that animation consistent with the sum total of the physical evidence?
The sum total, it is inconsistent.
And is Bob Durst's testimony, is that inconsistent with the sum total of physical evidence?
In my opinion, yes, sir.
I asked you before, if you had recovered the head, would have that been easier to recreate this crime scene?
It would certainly assist, yes, sir.
How so?
Number one, we'd know that there is a head with a gunshot. Number two, you could position the head in certain areas that would not be possible, and you would exclude those in producing the type of spatter that we have. and then position it within certain range where it would be possible.
And if you found the head, you could come up with any scenario depending upon what the head is inconsistent with the animation. Is that correct? Let me
I'm not
rephrase the
sure
question.
I understood that.
Let's say Bob Durst cuts up the body. He puts the body in the car. He's driving away. He's arrested, and the head is recovered. And it turns out that there's a gunshot wound that is inconsistent with this defense animation, right? It's not at the side of the head,
Oh,
right?
okay, I understand the question now. If it is in some other
Excuse me,
position,
the question assumes facts that are not in evidence, that are pure speculation.
Overall,
if it is not in the position that is shown in the video, obviously the head would have to be turned a different direction to get spatter on the wall. So that would be inconsistent with where it is shown being shot.
Nothing further.
Mr. Guerin.
First, there was a minuscule amount of blood on the wall. Is that a fair statement?
Well, it's relative.
Tiny, tiny specks of
Oh,
blood.
tiny, yes.
And as far as you know, that was the only blood spatter that was found anywhere in the apartment.
It's the only I am aware of.
Let's assume for a moment that it happened exactly as Bob Durst described it, and exactly as in that video. And assume further that the bullet struck Mr. Black on the left side of the bridge of his nose, and assume that it was a 22 that caused a 22 bullet that caused it. And assume that you cannot account for where the gun was from the time that Morris Black met his death until about 4 days later when it was found in a garbage can. Certainly the unexplained presence of the gun, wherever it was, whatever happened to it, could account for the fact that there was no blood spatter on the gun, couldn't it?
There are multiple possibilities as to why there is not.
One of the possibilities is that blood spatter just didn't get on the gun.
If it's outside the range, that is very, very possible.
Well, even if it's inside the range, there's only a chance that it would get on the gun, right?
Is it possible? Yes.
Okay. Now, you know, don't you, that different parts of the head have different thicknesses of bone.
Yes, sir.
For instance, the back of the head has very thick bone.
Yes, sir.
But the facial bones are delicate and thin.
They are.
And you would expect blood spatter to happen if shot in the face, wouldn't you?
Yes, I would.
It's not so clear that blood spatter would happen, say, in the back of the head, is it? Maybe because of
I would-
hair, because of a thick skull, whatever.
There are always a lot of variables. Some include what you're talking about, thicker skull, hair, skin. How does the skin tear upon the bullet entering? There's a lot of variables.
Okay, so I guess the answer is yes. You can't say with certainty that you would get blood spatter if shot in the back of the head, can you?
The best explanation as to whether or not there was blood spatter is there back spatter at the scene? That's the best explanation. If it isn't there, then you would predict that there wouldn't have been back spatter.
I think I understand what you say is that There's a chance there would be, and there's a chance there wouldn't be. Just put it down simply.
Related to this scene.
Related to the science, if you can call it science, of blood spatter.
I'm not sure what the question is.
Max Courtney made a statement in his testimony that you may find blood spatter and you may not find blood spatter. If you find it, that's the best evidence that there was some, but if you don't find it, that's not evidence that there was or wasn't.
That would be an accurate statement.
Okay, that's all.
Yes, Mr. Millian.
I'm not going to ask you about hypothetical lecture topics about backspatter. I'm going to ask you about this case. In this case, do you have evidence of backspatter?
Yes, you do.
Okay. Given that you have evidence of backspatter, would you expect to find backspatter on that gun?
I would expect and look for it, yes, sir.
And just to clarify, if it happened the way it's described in the defense animation?
That would be accurate, yes, sir.
Nothing further, Your Honor.
Mr. Garrett.
And of course, that last answer about expecting to find blood spatter depends on a lot of variations, doesn't it?
Yes, sir, it does.
A lot of variables.
There are always a lot of variables.
Number one being if you get the gun almost immediately after the bullet's fired and there's black backspatter.
If it did get on the gun, yes, you would see it.
But the longer the time goes from between the time the shot occurred and the time you examine the gun, makes it less and less likely that the blood's still going to be there, right?
It can be worn off with handling, but typically because of how corrosive blood is on metal, I would still expect if there was blood there that's been removed, that there would be evidence that it was there.
Well, that depends also on how fast it was removed, doesn't it?
Well, how fast, how often, whether it's being brushed against something or wiped, there's a lot of variables again.
Or whether the gun had oil on it.
Yes, sir. Oil would be a retard the blood from actually adhering depending upon how much was there.
So if it was a well-cleaned, well-used, well-oiled gun, it's less likely that you would find backspatter on it.
If it is sufficiently oiled, actually I would say over-oiled, it's less likely.
And of course, you don't know what happened to the gun in the meantime. All you know is that the gun was found in a trash several days after Morris Black met his death.
Yes, sir.
That's all.
Mr. Milius.
It's not just that the gun should have backspatter on it. When you look at the physical evidence in terms of the direction of travel, particularly on stains 2 and 9, that's inconsistent with the defense animation. Is that correct?
Yes, sir, it is.
Nothing further.
Nothing further.
May this witness be excused?
Yeah.
Yes, Your Honor. Thank you.
Yep.
Mr. DeGarren said yes, Your Honor.
I
You're
did.
excused. Thank you.
Yes, sir.
Mr. Balian.
The people pursuant to a stipulation are going to play All Good Things now.
All right, so this is a,
1 hour and 40 minutes.
ordinarily we take, it's too soon for our break. Is there can you sense a good time for an intermission in this film?
We could find one and whenever.
Popcorn.
By the way, Mr. Bailey and I offered to buy popcorn for everybody.
I heard that.
We got overruled. You said stop.
So let me talk. I need to give you some instruction on this point, ladies and gentlemen. The people are presenting what obviously is a dramatic film called All Good Things, which is based upon incidents alleged in this case. This film is not being received for the truth of any of its assertions or depictions, but only to help you understand and evaluate subsequent statements by the defendant, Mr. Durst. It's very important that you not confuse any depictions, statements, reenactments, or allegations in this film as evidence, except as I have described. That is, its permissible use is to help you understand and evaluate Mr. Durst's statements about the film. Only those statements made understandable by viewing the film are evidence in this case.
I don't know if anyone wants them, but we have transcripts. We can mark one for the. So can we mark the film itself as people 260 and the transcript as 260A?
Yes.
And any jurors that want transcripts, we have them.
Sure, I had a question.
What was the question? I'm sorry, which juror had? Yes, so alternate one, yes.
It was going to be shown with the captioning on.
No,
Okay, how's your sound quality on this?
it's off of a DVD, originally from a DVD, so I think it's pretty good.
You should be able to hear it, but this would, if you take this transcript, that would be just as good as almost as good as a caption. And that was alternate one.
Apologize, Your Honor. Slight technical difficulty.
Till 3:20, will it all fit? Ladies and gentlemen, do not converse among yourselves or with anyone else on any subject connected with this case. Do not form or express any opinion on the case. We'll return by 3:20. Thank you.
Your Honor. Thank you. Your Honor, earlier today we had a sidebar discussion regarding the blood spatter witness, and we renewed our objection to the use of information about the trial in Galveston, and in this instance, the state's attempt to suggest that the self-defense verdict was improper and that Mr. Durst had actually done something different than was determined in Galveston.
You're saying self-defense verdict, but it was a not guilty verdict.
Right, for self-defense.
I think was an accident advanced also and self-defense?
Yes.
Yes, Your Honor.
Thank you. Just to be clear. Go ahead.
Thank you, I appreciate it. So, we had indicated to the court that the theory that the state has professed for putting this forward was somehow that Morris Black knew who Mr. Durst was and thought that Mr. Durst thought he was a threat to reveal to him, to somebody, that he was Mr. Durst and he was on the run. Mr. Durst had not been charged with an offense at that time, so the fugitive argument didn't seem to us to be very strong, and I think that it would be fair to say, and if I'm mischaracterizing the court did indicate that there has been a thin link to this theory shown by the people, and we continue to object to it. We don't believe there's a nexus to their argument that somehow Mr. Durst was in fear of some disclosure by Mr. Black. Then there's a couple other issues, but we can address one at a time, please.
All right.
Very briefly in response, Your Honor. Number one, the fugitive argument was advanced by Mr. Durst himself, who has repeatedly stated that he went to Galveston because it was, quote, the farthest point I could get away from New York City because he was concerned about being charged in the case. That's not our theory alone, that's Mr. Durst's theory. Number two, the court made its ruling. Counsel seems to believe that somehow we are stuck with the verdict from Galveston. He's right about one thing. We're going to prove in this case that Bob Durst murdered Morris Black. We're going to prove it by the evidence that we're putting on, the fact that Bob Durst put the head inside of the trash bags, that he retrieved it. It was not a crab. It was not a large sea animal. It was not a shark, and it didn't sink below the ground. We're going to also demonstrate that his version of how the actual incident occurred is not only inconsistent with physical evidence, it's inconsistent with his own expert's testimony relying on the animation.
Okay, but that, regardless of that, Your Honor.
Are you done?
Yeah, well, I'm not finished.
Oh, I thought he was.
So, in addition, Your Honor, the court made an extremely detailed, we've litigated this by my count, something like 7 times. It's even gone up to the Court of Appeal and back. The court was very clear in why this evidence comes in. I think the problem that counsel has is, and this is, I think, recognized by the arguments they made in chambers, is that they don't understand that under 1101B, number one, his client's not in jeopardy. We have to prove to a jury before they utilize the evidence by a preponderance of the evidence. The standard for a jury receiving evidence for which they will decide by a preponderance is substantially lower. The circumstantial evidence in this case, which the court has reviewed in our motions, demonstrates that Mr. Durst clearly believed that Morris Black knew who he was, knew what he was running from, and that he had the motive to kill him. Everything else is argument for the jury.
Okay, so, Your Honor, I tried to make it brief because we've been over this, but I will respond this way, Your Honor. One, he was getting away from Gene Pirro, who the state has acknowledged has been a prosecutor without any kind of boundaries. So whether he was really afraid of the fact that he could be prosecuted for murder or whether he was afraid of this crazy woman is two different things. Secondly, on the idea that we appealed, as the court has noted many times, the Court of Appeals may have rejected that based on the fact that they know we have a remedy of law, which is the eventual appeal if for some reason we were to lose the case. Mr. Lewin keeps talking about how he's going to prove there's a murder, but yet he tells us that he's not doing this to prove there's a murder. His acknowledgement that that's what his real motive here, Your Honor, is exactly the prejudice that Mr. Durst has endured since this started. You have prevented us, Your Honor, yesterday, for example, with Becerra, talking about anything that would be a defense to what happened in South Salem, and yet every time the prosecution gets a chance, even though they claim it's to show some kind of a modus operandi of Mr. Durst or some plan, the reality is they are trying to convict him in Galveston, convict him of Kathy Durst, and it's revealed by Mr. Lewin's argument, who can't help himself but to be crusading to prove that Bob got away with a murder in Galveston. He should have been prosecuted in South Salem. Well, Your Honor, he won in Galveston. He's never been charged in South Salem. And I will say this also, Your Honor, Mr. Lewin's perception of what's happening here may not be the same as other people's. I'm asking you, Your Honor, just to make the record that the court has acknowledged that the connection with respect to Morris Black and the reason that they're presenting what they're presenting is attenuated. I understand the standard's different, but they can't have it both ways, Your Honor. They can't keep telling you they're doing it for one reason and then pronounce how they're prosecuting him for murder. And that's what he does.
So let me say, first of all, that the only reason I'm hearing this now is because I left it open. Should the people not present the evidence they described in the 1101 motion, that the court would reconsider. But it does appear that people have presented what they indicated at the time of the pretrial motion. The pretrial motion, it was a very elaborate argument by both sides. I incorporated actually the people's brief by reference, and I had the time to articulate reasoning, articulate evidence, refer to cases, and by presenting it again when I don't have that before me, sort of surprising me with it, means that that's all right, but the record here may not be sufficient. I would incorporate again the earlier ruling. You've mentioned this New York hearsay argument as if it had something to do with this, as if the court ruled in favor of the people in that case, therefore the court should not rule in favor of the people's argument here also. I don't really understand the connection between excluding hearsay and this 1101 evidence. The only thing that is really useful is a determination of what is relevant. What is relevant is evidence that pertains to credibility of a witness, or evidence that tends to prove an intermediate or ultimate fact. In the case of the New York hearsay, there was not evidence that, well, the hearsay evidence is excluded, and the non-hearsay purpose was not pertinent to an intermediate or an ultimate fact. There are two lines of cases about the opinion of a detective and when it is relevant, when it is that it matters why a detective did something. So in the narrative of what a detective did, it may be that their decision about what to do is an element. For example, when an element of the crime is or an element that needs to be proved is the lawfulness or probable cause, and that's not not the issue there. That's something I didn't refer to in this New York argument. That's just an example of, I know it's a little bit off, but off track here. But the point is that by making the argument in this way, the record isn't complete. Let's talk about 1101. The people are offering this based upon the idea that in part because Mr. Durst knew that Mr. Black knew who he was. So he's a witness to the identity, he's a witness. He knows that Mr. Durst is, rather than living a life of luxury somewhere, he's living under an alias in a boarding house in New Orleans. Why anyone would ask, why is somebody doing that? It's a curious state of affairs, and Morris Black knows, Mr. Durst knows, Mr. Black knows this fact. That's one fact that we know, one fact that he could be a witness. You're presuming that Mr. Durst is rational in making his decision that there must be some evidence that Mr. Black was going to turn him in, or Mr. Black was aware of the particular charges against him, rather than Mr. Durst having a consciousness that Mr. Black, if there were a prosecution, might be someone who could be a witness. But there's more to it than that, and I think the key is you keep criticizing the people for trying to prove murder, but really that's something that's been left out of the discussion, something that's important, because if Mr. Durst disposed of this body, disposed of the head, and in fact killed Mr. Black intentionally, all right, and not beyond a reasonable doubt, that's established. There's a reasonable doubt about this based on the evidence, but to a preponderance, if this was a murder, then what is the motive, right? The obvious question is, why would he kill this man? We have heard testimony of them getting along, they're friends, there's no reason for him to kill. If it's a murder, then the question arises, logically, why? What is the motive? It seems to me that the Morris Black killing and the Susan Berman killing, that evidence interrelates, right, to show motive, right? The thing they have in common, they're both friends of his who get killed, and they both are potentially witnesses, and that's quite logical. Anybody could. Is that true? That's a jury's call.
Most respectfully, Judge, where do you take the jump that Morris Black is a witness? To what?
Okay, I'm sorry. Morris Black is a witness if he can identify Mr. Durst. Period. I'm sorry. Don't argue with me. You asked me a question, which you shouldn't do, but I'm going to answer it anyway, Mr. Chesnoff.
And then when I get a chance, I'll respond, Your Honor. Please.
All right. Mr. Durst knows that Morris Black can identify him. He can testify, yes, Robert Durst was living across the hallway dressed as a woman and using somebody else's name. He says he doesn't want to be Robert Durst anymore. He doesn't want to be in New York anymore. That is evidence. That's incriminating. That makes him a witness. Is it the percipient witness? No. It makes him a witness. He could go to the authorities. He could it's possible. He's a risk. He presents a risk to Mr. Durst. That's a logical. Is that true by preponderance? I don't know. The jury will decide that, right? But is it logical? Sure it is. It's an obvious inference that you can draw from a person living under those circumstances, and and you leave that out. But there is that similarity to the Berman case where there's no reason for him to kill her. But if he did kill her, here's the question: is the special circumstance true? If he did kill her, and did, without any explanation, for some reason, murder Morris Black. Not just discarded the body parts because no one would ever believe him, but discarded the body parts to cover up a murder. That's the people's theory. Is that right? That's not my job. Is that a logical argument? Sure it is. Sure it is. And they can present that to prove the special circumstance of killing witnesses because of the modus operandi. It's a common scheme and plan to remove witnesses. A person who knows who he is, who can identify him, a person who can describe his conduct at the time of the, or assistance possibly. What the people's theory was the assistance as to covering up the circumstances of Kathy's death. Makes sense to me. I think it's logical. It's not a stretch.
Okay, may I say something?
Yeah, go ahead.
What about the scores of other people in Galveston that knew he was Robert Durst at the same time, Your Honor? He concealed his identity when he first arrived, and thereafter he operated under his name. He had checks, he went to the library, people knew that he was Robert Durst.
Yeah, but you say that to the jury. Yeah, of course.
Well,
you tell them.
But
I got to exclude the evidence because there's another explanation. If they're equal explanations, the jury must adopt that version favorable to the defendant. They must adopt the version that points to innocence. That's their job. But are the people allowed to present an influence that by a preponderance could be so? Yes.
Okay, except how can it be logical that Mr. Durst would be afraid of the guy who you just said was his friend when everybody else there knew he was Robert Durst? How do you make... That's not a preponderance. That's nothing, Your Honor. You're telling us that because theoretically he could have been concerned that Morris Black knew who he was when everybody else there knew who he was, that somehow Morris Black presented a bigger threat than the rest of them?
Not just possibly. I would say probably.
Your Honor,
I'd say probably because that's why else would he kill the man?
You know, I've said almost nothing.
Well, there's a lot of reasons why somebody might kill somebody,
If I
Your
can,
Honor.
I've said
They
almost
don't...
Right.
Accident, self-defense.
Sure.
How about you just get mad?
Tell the jury that. That's a good one for the jury. Yes.
Your Honor, very quickly, just because it's important that it's rebutted. What
Yeah.
Mr. Chesnoff just said about everybody in Galveston knew who Bob Durst was, that's incorrect. There's been no evidence put on to support that at all. What Mr. Durst did was, he was very careful. If he used his name, he used his name in a way where he was not connected to where he was living. So the person that knew Bob Durst was living in this location, and that therefore Janine Pirro and the New York authorities would have known where he was with Morris Black. I should add that if Mr. Chesnoff intends on making the argument he just made, I hope he's intending to put on evidence, because thus far, the court's been here. What he said, there's no evidence to support that. So hopefully, if he's got some evidence that will back up what he said, but you need to have evidence. And as the court was very clear, and by the way, Your Honor, the court's ruling on this was on January 15th, 2019, and it was detailed in every way. So with that...
Your Honor, I'm not quarreling that the court has explained this. It's just so striking to... You've been in our position, Your Honor, and you are now listening it's almost bizarre. You're listening to the state of California has no jurisdiction over what happened in Galveston, bringing in a witness to prove to this jury that somehow the verdict there was wrong.
That's not quite right. Actually, the verdict is right. The verdict is there's a reasonable doubt.
There you go.
The verdict's right. Reasonable doubt. That we are not. In fact, I'll even instruct the jury if there's a reasonable doubt. I'll do it.
Okay.
But the evidence is useful to a preponderance. If they find by a preponderance every one of those facts.
Wait, Your Honor. I know the court is.
We'll talk about it when we get to instruction.
Right.
Okay, we have a stipulation we want to talk to you about.
Well, that's good. You're gonna make me feel better about your presentation. No, okay, finish. Yes, I've been in your position, of course. I know what you're talking about. It doesn't, but you gotta be sanguine about the facts and the law.
Oh, you know I am, Your Honor. I'm just telling you at this point in time that, most respectfully, I don't believe that Morris Black knowing that he was Bob Durst is enough to present that to the jury, even for preponderance. But we've been through it. What I'd like to talk about is trying to work something out with my colleagues on the other side. They notified us this afternoon that they want to bring Mr. Becerra back because they forgot to ask him something regarding prior consistent statements of Nick Chavin. I have told them the following. I object under 352 to having this witness come back after he's been excused to highlight to the jury a piece of evidence that might be considered strong in terms of the prosecution case. So our argument is, Your Honor, they should not be able to recall him either for live testimony or for any proposed stipulation. Once the court rules, we can address whatever happens after that.
Okay, objection overruled.
Okay, so we have a stipulation. Put it
Further,
on the record.
The stipulation is going to be as follows, Your Honor. Mr. Becerra will, there'll be a stipulation that on March 1st, 2001, that Mr. Chavin gave a statement. Counsel has the statement after Mr. Chavin's, after he testifies. That information will be admissible as a prior consistent statement. We'll put it on then.
We will read it. We will read the portions of the reporting instead of recalling the witness.
Yes.
And they will add the portion that I wanted, which John can repeat.
Yes, and so we'll read in, it's a very small handwritten report. We're going to read in the report. We're going to add the following to that report. It will say that Mr. Chavin was not contacted by investigators in this case until March 1st, 2001. He never stated the information to anybody prior to that date.
Any police officer.
Any police officer.
Right, that's helpful, that's good.
Thank you.
Now, what?
Am I back
one more
again?
thing, a third thing.
we renew our objection to the showing of this movie.
Ah.
Your Honor, if I could make a movie, I'd make a movie about our theory. But this is a movie that really outlines the prosecution's theory. It's dramatized. We thought that it was going to be for admissions that Mr. Durst might have made while watching it, but this is just the movie itself. It's improper.
And again, it's
We
very
object.
brief. The court's already ruled on this. The problem for Mr. Durst is, and the only reason this movie is admissible, is he is shown the movie, and the comments that he says about the movie are, it was pretty much about what happened. This was not a hatchet job. He gets angry about one thing, and it's not about his involvement in 3 murders. It's the idea that he killed the dog. So this movie is one giant adoptive admission. The court granted our motion. We litigated this as well. And again, I understand that counsel doesn't like the court's rulings, but if the court, I think, is aware of this. They bring these issues up. There's not one new fact. There's not one new case. There's nothing. There's simply, Judge, we think you got it wrong. So we'll submit on the same arguments that we've been making for 5 years.
I guess it's in the totality of the circumstances while you're in the trial and while you're watching how the evidence is coming in, that you have an obligation as a defense lawyer to raise those issues as they impact the jury that we're in front of now, Your Honor.
And now that the court is able to see this melodrama, the court should see that your ruling was wrong. They shouldn't be allowed to play that.
So it is a melodrama. I think it's very important that I instructed the jury that we have a bright jury. I trust them to follow my instructions. I'll repeat the instruction later on. I think it's very important that this was played at the end of the evidence, near the end of the evidence. The jurors already know what happened. They see what's a dramatization and what is not. And to the extent they didn't, my instructions should take care of it. So I appreciate your objection to that, but I do overrule it as I overrule your 1101 objection. The other point I want to make,
Before you get away from that,
Okay.
we think that your instruction is wholly inadequate to cure the harm that's done by this melodrama.
Well, wait a second. I read an instruction to you. You agreed with it wholeheartedly. So that's peculiar that you say that it's inadequate when I gave you a chance, and you certainly did not suggest anything else I ought to say. So I will give you yet another opportunity to supply me with additional instructions. Now, you may be saying that no instruction could possibly cure this. And I'll take that. I mean, if that's what you think, I think mine goes pretty far. But
It was really good.
We'll even, if the court wants to appease the defense, if before they watch another second of the movie, if the court wants to say, even now listen, there are things in this movie that were not only dramatizations, but that are not only not in the evidence, they are inconsistent with the evidence. You are not viewing this movie as a documentary of what happened in this case. You are viewing it, again, you know, we've been more than willing, more than agreeable. The court's absolutely right. The defense spends a lot of time complaining about the court's rulings, et cetera. Then there's no motions filed, there's
Well,
no,
we filed all of them,
There's-
Your Honor. We filed plenty of motions about this.
So it's, not only is it dramatization, portions are clearly fabricated.
yep.
And others are inconsistent with the evidence.
The others are inconsistent with the, do you want your client to speak?
I want to ask him what he wants to ask first.
Okay,
Your Honor.
yeah, why don't you do that?
Okay. Here, Bob?
Your Honor,
Well, one second, Bob.
Wait, talk to Mr. Chesnoff first.
Wait. Here. Right here.
I want to testify without wearing a mask.
Okay, we'll bring that up to him. I'll take care of it. Not at this time, Your Honor. Thank you.
All right, now, you threw three things at me, I'm gonna throw something back at you. Now, this is the, I understand from the schedule that the people may conclude their evidence as early as the 28th. If so, I believe the defense case should begin on the 29th. You have a local witness, don't you?
Yes.
Let's be ready to start on the 29th, please.
Okay.
Thank you, Your Honor.
You're welcome.
Can we take 5
Take a
minutes?
real recess and go till 3. Will we finish the film if we go to 3:45? Maybe we'll go to 3:40. Is
Thank
that
you, Your
10
Honor.
minutes enough? 10 minutes enough, 3:40.
And Your Honor, we have one last signed stipulation. We will just present it to the clerk.
Thank you.
Start, guys.